All right, good afternoon, everybody. My name is Jeff Smith. I'm a shareholder here at Altitude Community Law. I'm also the head of our litigation department, so I do a lot of this discrimination work, as well as some covenant enforcement and other things like that. Today, we are going to talk about unintentional discrimination by associations. This is an important topic. One of the main things that I want you guys to get out of this is that when you're dealing with reasonable accommodations, reasonable modifications, please make sure you get that to your attorney to review because there is a substantial amount of liability that can come from this. But first, let's do some quick housekeeping. On your screen, you'll see the PowerPoint presentation in the center of your screen. This should take up the vast majority of the screen. There should also be a small box on the bottom right-hand side of the screen with the video feed. That should have me on it. On the left side of the menu, please select the questions and answers icon and type all your questions there. There's a lot of information here, so we'll try and get through this as fast as we can to hopefully answer some questions. Again, I'll try and address those at the end of the webinar. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report and will be sent via email within 48 hours following the webinar. These credits are not transferable. Please email Summer Sims at ssims@altitude.law or call 303-991-2076 if you have any questions about receiving your CMCA certificates. All right, with that, we will get going. All right, so discrimination in general. There are two relevant statutes that are going to come into play. I apologize, I have a little bit of a cough, so hopefully that doesn't keep going. You have the FHA, which is the Federal Fair Housing Act, and you have the Colorado Civil Rights Act. They are very similar, but there are some discrepancies that we'll talk about. You also hear some talk about the ADA, the American with Disabilities Act. Typically, that doesn't apply to associations, but we'll address that a little bit later on in the slides. So what is discrimination? Discrimination is treating individuals differently with respect to sale, rental, or use of dwelling based on one of the following protected classes: race, creed, color, religion, sex, handicap/disability, familial status, marital status, national origin, ancestry, and sexual orientation. As you can see in some of these parentheses, you have those differences between the federal statute and the state statute. Creed, marital status, ancestry, and sexual orientation are only going to be state claims, while the rest of them will be both federal and state claims. The ones that we see the most in Colorado in the HOA world are going to be handicap, disability, or familial status. Those are the largest ones that we see the most complaints that get in front of the Colorado Civil Rights Division. So those are kind of the big ones here, but we'll discuss a little bit of all of them. So discrimination in the HOA context. Discriminatory treatment. These are things that are in your declaration or in your rules and regulations that discriminate on their face. So the language itself is discriminatory. So that might be something that says no children under 18 can use the common elements. Something along those lines. Maybe if you have really old covenant documents, you might have something that says that you have to be a certain race to live within a community. That would be something that is discriminatory on its face. We don't have very many of those anymore, but just as like a general background of what's going on, covenants originally were developed to keep certain races out of certain neighborhoods. That was the main purpose of covenants back in the 50s. In the 70s, you saw the laws change, and so all of those became unenforceable. You still see occasionally, there's at least one HOA in Colorado that still has that language in its declaration. It's not enforceable, but that's kind of where the history of covenants came from. Now, in the 80s and 90s, you had builders using them to basically keep uniformity within the community. So you see a shift from who can live there to how the property is going to be used. So what color your house has to be, whether you can have sheds, things like that. In terms of disparate impact, this is something that appears to be facially neutral on its face, but has a discriminatory impact. So maybe you have something that states in a rule that no one can play in the common elements, or no one can ride a bike in the common elements. It's kind of an easier one to use. So no one can ride a bike in the common elements. While that looks like it's facially neutral, what that really is probably is something that's going to affect children more than it's going to affect anyone else. So you may be discriminating against children based on familial status if you have something like that. So it's important that you have your attorneys look at your rules and regulations and give you some type of understanding of what is and what cannot be enforceable. But that's something that we have to deal with. So you have both discriminatory treatment and disparate impact. Ultimately, discrimination in the HOA context is a refusal to allow a reasonable accommodation or modification to a person with disability. So if an individual, whether it's an owner or a tenant, comes and says, hey, I have a disability, I need some type of accommodation or modification, and the HOA doesn't allow that, that's where discrimination can come in. All right, specific case studies on discrimination. So we're going to go through a couple cases here from some different states and a couple from Colorado as well, talking about different rules that come up often in HOAs and issues that have come up from it. So one of these cases is out of California. This is the Landsman case. This is an association that had 3 swimming pools. They had the main pool and 2 smaller auxiliary pools. They also had a gym and a bunch of other rec facilities. Their rules stated that no supervision is provided in either the pool areas or the gym. Children under 18 were prohibited in the main pool area. They were allowed in the auxiliary area, but not in the pool area. One of the reasons that they stated in the case why they wanted this is that the association preferred the relative tranquility of a swimming pool not filled with active and noisy children. Ultimately, the association was trying to create for its older residents a kind of peaceful area. The court, in this case, did not like that rule. Ultimately, they said you're discriminating against anyone under the age of 18 by saying they're not allowed into the main pool area. That is discrimination based on familial status. So when we are talking about pool rules, oftentimes what we'll be looking at is they're going to be an unmanned pool. And you'll see lots of times that there's language about no one can be there, a child can't be there without supervision. Again, a lot of those rules aren't going to be enforceable. There is some health and safety. The case law is pretty clear that anyone under the age of 14, you can require having a parent there with them unless that child can show that they're a competent swimmer. So if you have someone who is 10 years old and is training to be an Olympic swimmer and is a competent swimmer, that individual would not have to have an adult with them because the health and safety is going to go away because they're not going to drown. Now we can make them show that they are qualified swimmers, but we can't just outright prohibit them without some type of leeway to show that, yes, you can be there if you're a good swimmer. So when we're looking at pool rules, that's one of the main changes that we will see is having to make some type of adaptation as to who's allowed to be there and whether or not they have to be accompanied by an adult. Often when we see those accompanied by an adult, what they're really trying to deal with is behavior. So it's kids running wild. They don't want that happening. And obviously that's a valid concern, but that's a concern for anyone. You can have a 30-year-old being drunk at the pool, and that's problematic. So you can't limit that based solely on age. If we want to deal with someone's behavior, then we have rules that say you can't run, you can't have loud noise, you can't be things like that. That is something that would apply to everyone and would not be discriminatory. So these are the things that we would be looking at when you provide us with your pool rules. Next case, another swimming pool case. This one's out of Florida. This is the potential case of a Baby Ruth, floating Baby Ruth. In this case, the Covenants for a Florida Community Association prohibited children under the age of 5 from using the swimming pool and further restricted children between the ages of 5 and 16 from using the pool from 11 a.m. to 2 p.m. each day due to the possibility threat of fecal matter in the pool. So again, another concern is sanitation. However, this is not something that is also just strictly geared towards children. You have older individuals who have issues with controlling their bladder. You obviously have younger ones. The court said that you can't just say that you can't have someone under the age of 5. What you can do is say that they have to have proper swimming attire. So if it's someone under 5 or older that needs to use some type of a special diaper, that is something you can require. So as long as you put something in that says they have to have proper swim attire, you can do that. You can't just prohibit people that might have an accident in the pool. Likewise, putting a limit that someone who is 5 to 16 can't use the pool from 11 to 2, that's problematic. Everyone else has the ability to use the pool except for this age group. That's why it's discrimination. So if you want to shut the whole pool down from 11 to 2, that would not be an issue. If you wanted to do only lap swim from 11 to 2, also would not be an issue. But you can't carve out a section of the population and say they are not allowed to use this pool from a certain time period, for a certain time period. All right, the next case is our group home case. This is a Colorado-specific case. This case gets cited in cases all the time, whether it be for a group home for a drug rehab, a group home for youths that don't have parents, whether it's we see it a lot recently with the older generation. It's a group living facility for older age individuals who may have some type of anything that they might require a communal setting. They go in, they buy a house. These companies set it up that typically 8 beds is kind of their sweet spot, 8 to 10 beds. So they'll convert the garage, they'll do these different things, and then they'll set up some type of a group home. In Double D Manor versus Evergreen, this was a group home, but for use. Double D is a Colorado nonprofit corporation, which provides a home life situation for developmentally disabled persons between the ages of 5 and 21. Evergreen Meadows is a Colorado association, which covenants have provided. All sites shall be for residential use only, with only one single family dwelling permitted on any site. Under this case, the Colorado Supreme Court stated that single family dwelling does not relate to how many people are in the house or if they are related to each other, but single family dwelling describes the type of structure which is permitted, not the type of use that can be made within the property. So what this case is coming down and saying is that single family dwelling just simply means that it's not a multifamily house. So it's not a duplex. It's not a triplex, anything along those lines. It's just a single family home. So it really was a zoning type requirement, not to deal with the use. Residential use, although there is a commercial aspect in that there is a receipt of funds to run the home, the use of the structure is what's important. So the use of this structure, these individuals ate dinner together, they ate breakfast together, they slept there, they did all the things that anyone would do in this home. And so that is what the Supreme Court determined was most important. It's how they are using the home. Are they using it like a home of anyone else? So if you had a large family of 7 or 8 kids, is this any different than, is the house being used any differently simply because these people aren't related? The court in this case said that, yes, the use of the structure is as a home. Like I said before, they're eating together, they're playing together, they're sleeping there together, using it just like any other family would be using the home. So based on the nature of the activities, the facilities functions like a home, and therefore group homes can't be disallowed here in Colorado. So again, as we've talked about briefly, the big thing that we're seeing with group homes tends to be they move into a neighborhood, they convert the garage. There is some aesthetics things that we can deal with in terms of that, but oftentimes we'll still have to grant modifications, reasonable modifications to the home. But we can make it still look like a house from the outside. So if we want to keep a garage facade there, a garage door facade, we might be able to require that. We may be able to require other things to make it look that if you drive by the home, it looks like any other house. But an HOA is not going to be able to prohibit a group home, whether it's for disadvantaged youth, whether it's for drug addiction, whether it's for rehab of some kind, or whether it's for older community that might have memory care type situations, things like that. There's obviously other statutes that those homes have to comply with, but from the HOA standpoint, we don't have the ability to prohibit a group home. All right, next case we're going to talk about, excuse me, is Wagita versus Alamonte Heights Condominium Association. This is a case with a service animal, actually an emotional support animal, not a service animal. So one thing to keep in mind, emotional support animals can basically be any type of animal. They don't have to be specifically trained. They basically are there to typically deal with some type of a mental issue that is going on. A service animal is different. A service animal has to be either a dog or a miniature pony. It is going to have to be trained to do a specific task. And once you can prove that that specific task is being done, then they're going to be able to get their service animal. Typically, if you're dealing with a true service animal, it's not an issue. Those individuals are going to know the laws. They're going to provide you with the required information. They're going to show you that this dog has been trained. It's trained to do this exact issue, this exact task. I have a disability, and those are the easiest ones to deal with. What we most commonly see are emotional support animals, which is what this case is about. So in this case, you had a U.S. Air Force veteran, Bogita, suffered from PTSD and acquired a dog named Kane. Mr. Bogita's psychiatric symptoms improved significantly with Kane, and he began to rely on the dog to help him manage his condition. This Florida association had a weight limit on dogs in the community. Kane was significantly larger than the 25-pound dog weight limit. Mr. Bogita provided 2 letters from psychiatrists explaining his condition, the need for emotional support animal, and the therapeutic relationship with Kane. In response, the association requested the exact nature of his condition, whether Kane had received specific training, and why he needed a dog that weighed over 25 pounds. So there's a couple issues with what the association asked for. One, we don't get to ask what specific condition someone has. All that we can ask for is the individual disabled? Does the individual need an accommodation in order to enjoy equal use of the property? And is the requested accommodation reasonable? So those are the only 3 questions that we ask when we get this kind of information, when we get a request like this in. When you start asking for additional information, that's when you can become discriminatory simply by what you've asked. So it's always something. This is one of the main reasons that when you get a request for a reasonable accommodation or a reasonable modification, that you want to get this over to your attorneys as fast as possible to help limit any liability that the association might have by trying to do the right thing but misstating some questions that they might have. Additionally, we'll talk about a little bit later as well, if you don't have a reasonable accommodation policy for your association, you should certainly get one. It's going to lay out the steps that an owner needs to go through in order to request one of these. It's going to help the association have a policy or plan in place to show what steps need to be taken and how the process will move forward. It'll also have a sample letter of this is what we need from your doctor or medical professional. So I'd highly advise that if your associations do not have one, that they get one of these, because these are extremely common right now, especially with support dogs, especially if you are an association that puts limits on animals, whether it be size or weight, or if you have a fee for having a dog. All of those things will lead to more people filing or claiming an animal as an emotional support animal. So what is a disability? The disability is either a physical or mental impairment which substantially limits one or more major life activities. Now, this life activity might be walking, it might be working, it might be talking. There's a lot of things that can be a major life activity. And physical or mental impairment, this is obviously a very broad definition. So I've seen asthma be considered a physical impairment that limits one that required a reasonable accommodation. Most of them you're going to see have something to do with mental illness, PTSD, something along those lines. But again, this is a very broad, so a lot of things fall under disability. It's not the more common understanding of disability of someone being in a wheelchair. It's not just that. It doesn't have to just be a physical impairment such as that. We also need to have a record of such of the impairment. So if someone does happen to be in a record of such impairment or being regarded as having such an impairment. So if someone is in a wheelchair, we don't get to ask that person if they're disabled. We can see just by looking at them that they have a disability. And if the accommodation or modification that they are requesting goes towards some type of mobility issue, then we don't have the ability to ask, are you disabled? Now, if we can't see that, if it's something that's mental, that is obviously something that we can't outwardly see. So in those cases, we do get to request from the owner additional information or tenant. Physical mental impairment includes, but is not limited to, the following per the Housing and Urban Development and the Department of Justice Joint Statement of Reasonable Accommodations under the Fair Housing Act. Such diseases and conditions as orthopedic, visual, speech, and hearing impairments, cerebral palsy, autism, epilepsy, muscular dystrophy, MS, cancer, heart disease, diabetes, HIV, mental retardation, emotional illness, drug addiction, other than addiction caused by current illegal use of controlled substances, and alcoholism. So one caveat to that group home is that if someone is there and is actively using, that can still be problematic. If they are there and not using and they're just there for rehab, then we can't prohibit those individuals from being in that home. So what if you're not sure if a person is disabled? Can you ask for verification? If appropriate, the association may request information that is necessary to verify that the person meets the definition of disability, describes the needed accommodation, and shows the relationship between the person's disability and the need for the requested accommodation. So yes, we can verify if we can't outwardly see it. We need to then ask the question of what is the accommodation that they want, and then we want to see the nexus between whatever their disability is and the accommodation. So if someone says that they have a mobility impairment and they need an accommodation to have a curb cut out for their parking space. If we get the necessary information, that is something that we're going to have to provide. With curb cutouts, that is going to be an accommodation based on case law. And so the courts are going to say that the association needs to provide that cutout at their cost. In the same vein, if that same individual is wheelchair bound and they need to have a ramp that goes from the common elements to their unit, that's going to be a reasonable modification. So modifications are going to be changes to the physical property. And I know it sounds a little weird given the curb cutout. The curb cutout is a special one, which is the only reason why I bring it up for accommodation. Courts see that as accommodation instead of a modification. With a modification, the owner is responsible for paying for it most of the time. So again, you want to confer with your attorney, but the vast majority of modifications are going to be the responsibility of the owners. So when we have these requests that come in, and again, this would be set up in your reasonable accommodation modification policy, we need to be able to verify the person meets the definition of disability. Either we can visually see it or we get a note, a doctor's note, or from a medical professional. We need to know what the accommodation is that they are requesting, and then we have to see the nexus. If someone is saying that, sometimes we'll have someone request an accommodation that has nothing to do with their disability. So this is someone who has, say it's someone that has PTSD. If they were requesting a accommodation that said they didn't have to move their trash can back from the front of the driveway up to their house because of PTSD, the likelihood is that that's not a reasonable accommodation. That doesn't really have any nexus to that disability. Some of PTSD asking for a support animal, that's different. That would be something that would have a nexus. Who is allowed to provide verification? Does it need to be a doctor? Short answer is it does not need to be a doctor. It can be a doctor or other medical professional, a peer support group, a non-medical service agency, or a reliable third party who's in a position to know about the individual's disability. They can also provide verification of a disability. In most cases, an individual's medical records or detailed information about the nature of a person's disability is not necessary for this inquiry. So all that we need from that medical note is to say that the individual is disabled pursuant to the Fair Housing Act, and that's pretty much what we need from them. Sometimes we might need additional information depending on what the accommodation is, but for the most part, as long as the medical professional states that they are disabled as defined by the FHA, that's kind of the end of our inquiry. Does the individual need the specific accommodation in order to have equal use and enjoyment? So there has to be some relationship with the person's disability and the need for the requested accommodation, as we've already kind of talked about. So again, you could have a accommodation where a service animal, support animal is needed. That also doesn't change the fact that they still have to follow some of the other rules. So you might have a dog on leash only rule in your community. It's possible that the owner would need an accommodation from that dog on leash, depending on what exactly the dog was performing. If it's a support animal and the dog has to be able to notify other people or perform some task that a leash would be impossible for it to do its task on, then you would have to grant an accommodation from that leash rule. In the same vein, however, a person who has an emotional support animal or has a service animal still has to pick up after the animal. So if the animal is pooping all over your common area, that owner still has to pick it up. If they can't themselves pick it up, they need to hire someone to come out and pick up that poop on the common elements. Likewise, if they weren't keeping care of their property with poop, same thing. They'd have to pay someone to come out there and do it if they can't do it themselves. So that's an important thing. Also with barking, if the animal is being a nuisance, that's not something that we would make the accommodation for. The owner still is responsible for making sure that the animal is doing what it's supposed to be doing outside of the accommodation. So the accommodation is, yes, you get a dog, but your dog can't be barking the entire day and disrupting everyone else. So we still have some actions that we can take, even if there is an emotional support animal or a service animal. So what is considered a reasonable accommodation? The accommodation cannot impose an undue financial or administrative burden on the association, and the accommodation cannot fundamentally alter the nature of the association's operations. So one of the examples that you see in terms of fundamentally altering the nature of the association's operations is you have an owner who might be wheelchair bound. They can't really leave their house, and they are requesting that the association come and deliver them groceries. It's not as big of a concern anymore because we have so many delivery services, but in the late 90s when you didn't have that, there were a lot of cases around that. The association does not deliver groceries for people. It would not be reasonable. It's not something that would be the association is set up to do. It wouldn't be reasonable to have an association have to make that type of a accommodation. Accommodations that can impose undue financial or administrative burden on the association, these aren't quite as common. Most of the time what you're doing is you're accommodating a rule. So it typically has very little financial or administrative burden on the association, whether it's a no dog rule, whether it's a whatever type of rule, a pool rule of kids. It does not typically have an undue financial administrative burden, but in certain cases it might be. So again, that's something we would look at. If there's going to be a great cost to the association to have to provide this accommodation, that might be grounds for denying it. So that's what we're talking about when we're talking about reasonable. It's not talking about the fact that we don't think it's reasonable for them to have a 60-pound dog when a 30-pound dog could do the same thing. That's not the reasonable that we're talking about. We're only talking about reasonableness in the terms of, does it fundamentally alter the nature of the association's operations, or is it an undue financial burden for the association? So we briefly talked at the beginning that there's another statute that oftentimes owners and tenants believe applies to associations, but typically does not. That is going to be the American with Disabilities Act. That's the ADA. The ADA prohibits discrimination and ensures equal opportunity for persons with disabilities in employment, state and local government services, public accommodations, commercial facilities, and transportation. Again, most associations are not places of public accommodation, and that's why the ADA does not apply in a typical association setting. Now, there are some times where it will apply. One of those times would be if you're in a downtown condominium unit. Say it's a high-rise. The first couple floors are commercial, maybe up in the mountains, something along those lines. In those commercial units, the general public is welcome to be there. They come in, they go out. That is a place of public accommodation. So on those first floor, those commercial units there, that would be a place of public accommodation where the ADA would apply. So all of the things that the ADA requires would be subject there. Now, once you move from that area, that commercial area, up to just the residential area, that is not a place of public accommodation. In those cases, just the FHA would apply, not the ADA. Another time that the ADA comes out is in a pool setting or gyms, clubhouses. If you rent your clubhouse out to the general public, someone that is not a member of the association, that may make your place a public accommodation that may require ADA compliance. Likewise, if you have a competitive swim team and you are having other swim teams come in for a swim meet, that would likely make your pool a place of public accommodation, which would require your pool to be ADA compliant. We have some communities that they have a pool to generate additional money. They might sell memberships to that pool to people outside of the association. Again, that might make it a place of public accommodation, which may require compliance with the ADA. So if you're doing any of those types of things or have those concerns, the ADA may apply, and you should consult your attorney about that. I'll tell you the vast majority of complaints that we get from owners or tenants, they almost always refer to, when they're talking about disability, that you are violating the ADA. What they really mean is you're violating the FHA. The laws are pretty similar, although there's a few more requirements with the ADA. But typically when they say you're violating the ADA, they really mean the FHA. All right, so a couple of other case studies that we got here. Gittleman v. Woodhaven Condominium Association. Mr. Gittleman suffered from a disability, requested exclusive use of a parking space to accommodate his disability. The New Jersey Association rejected Mr. Gittleman's request based on its master deed, which provided the parking space within the lands described in paragraph 1 of this master deed shall constitute common elements for the non-exclusive use of the owners. The association argued it can't grant the request without amending the above, which required 2/3 owner approval. They tried to amend but failed. Ultimately, in this case, because the parking spaces were common elements, the court ruled that the reasonable accommodation was to the non-exclusive use of the unit owners, and therefore we could create a space that was designated just for this individual. That's a little bit different than in a case where if you have parking spaces that are individually deeded to each unit, in that case, the association doesn't have the power to go ahead and tell one owner, hey, you need to move your parking space that's been individually deeded to you to a different parking space. But if it's common element, whether it's general common element or limited common element, the association likely is going to have the responsibility to provide an accommodation to the owner and get them a parking space that is closer to their unit. Additionally, that might require some type of curb cutout, things along those lines as well. But we have lots of parking issues that come up in terms of, we all know that parking is tough in condominiums. There's never enough parking. There's rarely enough handicap parking. So there's different ways that we have tried to deal with that. Sometimes we will try and increase the number of handicap spaces. Sometimes we might move the owner to a spot that's closer and put a sign up that says parking by permit only and only hand out one permit, and that permit is to the owner who needed the accommodation. There are lots of ways that we can try and get around the parking issues to help these individuals get closer for mobility impairments, but that is a big one that comes up. So one to be aware of in terms of both ramps, cutouts, and actually moving parking spaces. So this next one is Charles Hollis versus Chestnut Bend Homeowners Association. In this case, plaintiffs made numerous requests to the Architectural Review Committee to add a sunroom for the purpose of creating a particularized living environment designed to therapeutically stimulate the development of two of their children who are physically and mentally disabled. The owners submitted multiple requests, and the fourth and final request expressly stated that the sunroom was being requested as a reasonable modification of their home under the FHA. The association responded back to them with additional requirements. So in terms of this, the owners submitted a letter from a medical doctor saying that their children had disabilities. They stated the accommodation or modification that they needed, which was adding a sunroom. And the nexus between it was that sunroom provided a stimulus area for these young children to be able to better develop. The association ultimately came back and said, no, we need more information than this. You have not provided us enough information to make a determination of whether or not a modification is needed and or reasonable. So associations must provide reasonable modifications to disabled individuals if needed to afford the individual equal use and enjoyment of the unit and community. So again, first thing we're going to ask, is the individual disabled? In this case, yes, they were. Does the individual need modification in order to have equal use and enjoyment? In this case, the parents were saying that the children could not properly use the house unless this modification was done because of the specific disability that they had. The next question is the requested modification reasonable? Here again, it's a single family home. The sunroom is not going to affect any of the other owners. It's not going to put an undue burden on the association financially, and nor is it going to change the actual purpose of the association. So in this case, who would pay for the modification? So again, with modifications, this is going to be something that typically is going to be the homeowner's responsibility. There are some caveats to that. If multiple people are going to be using, so say you have a electronic lift that's going there, and there might be multiple people that are using it, that might change who has to pay for it. Also, in terms of maintenance, that might change who has to maintain it. If more than one person is going to use it, or if the entire community can use it, that can change who's responsible for it. And can you make them remove it if it's no longer needed? So typically, once the modification goes in, if the owner moves out, we can't require that the modification has to be removed. We can't put that stipulation on it. So typically, we don't have the ability to make them remove something if it's no longer needed or if they move from the property. So the case of the mezuzah. This is another Colorado case. The individual plaintiff who brought this against the Shoreline Towers, their child was a member of the Colorado State Senate, I believe. It might have been the House. The condo resident sued the association and its president under the FHA because the mezuzah, religious symbol that they placed on the unit's door post, was removed pursuant to a rule adopted by the condo association, which stated the objects of any sort are prohibited outside unit entrances doors. So ultimately, you couldn't have anything on your front door. This was removed. The individual then sued the association. Ultimately, what ended up happening, because the plaintiff child was in the legislature, a new law was enacted, an amendment to Kiowa. And under that new law, an association shall not prohibit any of the following. Specifically, the display of a religious item or symbol on the entry door or entry door frame of a unit. So in this case, ultimately, the association, although they had a rule that said that you can't put anything on the outside of your doors, the state went around that and created a new law which said, yes, the display of religious item or symbol on the entry door is allowed. And so now if anyone puts up a cross or a mezuzah or anything along those lines, there's nothing the association can do about it. Again, ultimately, in this case, the association, the reason that they had the outside of the door, why they didn't want it on there, is they had the maintenance responsibility, so they didn't want the holes to have to deal with. But again, that's something that we can no longer do. You can't put those restrictions on there anymore with regards to religious items or symbols. All right, let's talk about enforcement. I'm going to try and get through this fast because I see you guys have a bunch of questions, so I can hopefully get through these questions in our hour time frame. All right, so who are the enforcers of discrimination in Colorado? So you have the United States Department of Housing and Urban Development, HUD. Their mission is to ensure the access of every American to a decent, safe, and sanitary home and suitable living environment. The other enforcement agency is the Colorado Civil Rights Division, which we will almost always hear referred to as the CCRD. HUD has certified that the CCRD is substantially equivalent agency. So most cases, the vast majority of them will go through the CCRD office. They won't go through HUD. Occasionally, you will have HUD step in or not turn this over to CCRD, although most of the HUD ones end up being have to deal with kind of bigger issues. The CCRD are the people that dealt with the baker and the cake case and all of those things. So they also deal with the EEOC and things along those lines. But the CCRD is a state agency. They are there to basically impose that every individual has the ability to have access to the same housing, regardless if they are disabled or if they have any other type of protected class status. So they're the ones that are there to protect against any type of discrimination. So who is the CCRD? They're a government agency that enforces Colorado's anti-discrimination law. They work with the EEOC, which deals with employment, and with HUD, which deals with the housing complaints. They are going to investigate claims of alleged discrimination. So CCRD complaints. One thing to know, if you get a CCRD or HUD complaint, you need to get it to your attorney as fast as possible. The turnaround time to file a response to these is only 10 days. Now, in almost every case, we'll get it. We will reach out to the investigator, and they will give us roughly a 2-week extension. But even with that, we only have 3 weeks to get all the information together and draft our response. So you need to get this to the attorney as quickly as possible. So under the CCRD, the formal complaint is filed free of charge. So it's not the owner who is actually filing the complaint, it's the CCRD. Housing complaints. They must be filed within 1 year from the date of the last occurrence of the Discriminatory Act, or CCRD will not investigate a claim. I have not seen a owner miss that 1 year. Typically, they file these complaints pretty quickly. One of the reasons for that is talked here a little bit later, or talked in our next one. There's no cost to the owner. So the owner turns this over to the CCRD. The CCRD drafts the charge. They serve it on the respondent, which oftentimes will be the association, the management company. Oftentimes they'll list the specific manager, and they might list specific board members as well. Those respondents are given a chance to respond and provide information. So we'll ask you guys for any communications you've had with the owners. We're going to ask you for, obviously, any governing documents that we don't have. We're going to ask you typically for a log of all of the a lot of times these come out of enforcement type actions where they're saying you're treating me differently than someone else because of my race or my sexual orientation, any of those kinds of things. We're going to ask for any and all covenant enforcement violations that you've sent that might deal with this to anyone in the community. So, and sometimes we'll ask for all the covenant violations for a community that's been sent over a 2-year time frame. Ultimately, what we're trying to show to the CCRD is that we're treating everyone the same. I mean, ultimately, that's all we can do is try and treat everyone the same. The fact that they might fall under a protected class does not mean that we're discriminating against them. We're simply following what we're supposed to do in our policies and procedures. So if they are saying that you're sending me these violations for not pulling weeds and you're not sending them to anyone else, we want to get every weed violation you've sent over the last 2 years. If they are saying that you're picking on me and you're only giving me a ticket for parking in the wrong place, we're going to want to know all of the parking violations that you've sent. If it's something broader than that, we might want all of the violations that an association has sent. So we can say, look, the association has sent 400 different violations over the last 2 years to everyone in the community. We're not singling this individual out. This is just simply they violated the covenants. We sent them a violation, and their response was to say they were being discriminated against. So once we respond, it usually takes the CCRD roughly 6 to 9 months before they make a determination. Lately, they have been asking for interviews. So typically they will interview the manager and or maybe a board member, depending on what the complaint is. Once they have gone through that process, they'll issue a determination of either probable cause or no probable cause. If it's no probable cause, that's a win for the association. The owner still has the ability to move forward with a federal complaint, but typically they do not because you already have an administrative agency saying that no discrimination took place. The CCRD is always trying to have dispute resolution take place, some type of ADR. So you might have a mediation before the response is done, depending on what's going on with the actual complaint. So we may reach out to them and say, look, we'd like to have a mediation. We'll talk to them. There are certain requirements that the CCRD will have to any type of stipulation. Typically, it's going to require that the current board take an hour-long discrimination class. And then there may be some other things that have to be put up in terms of specific signs or different things depending on what exactly is going on in the complaint. Like I said, the CCRD investigation usually lasts around 6 to 9 months. Sometimes they'll ask for a 90-day extension. The division director makes the determination. They pretty much they'll assign an investigator. The investigator will go through all the documents. The investigator will hold its interviews, and then they will draft up their determination for the division director. The division director will then review the information and make the final determination. If the determination is that there is probable cause that discrimination took place, the next step is what's called conciliation. This is basically like a forced mediation. So we would be in the conciliation. Both sides would be kind of stating their case, but ultimately the CCRD is going to say, look, in order for you to reconcile what's going on here, these are the steps that we're going to require. You may need to pay a fine. You're going to need to take these classes. You're going to need to amend your rules. You're going to need to do X, Y, Z. We don't have a ton of power or leverage in a conciliation. We kind of have to take what they give us. If we don't take it, then we go in front of the Colorado Civil Rights Commission, and you have basically an administrative trial, and we try and prove that we didn't discriminate. It's not really where you want to be. Most of these cases, the vast majority of these cases from an association standpoint come back as no discrimination took place, which is great. Most of the associations and you guys as managers are doing a great job getting in front of these things and making sure you're treating everyone the same. But in those cases that do find probable cause, we typically want to resolve them at conciliation simply because of the cost and the potential liability to the association if we end up having to go in front of a trial, go have a trial in front of the administrative court. Additionally, in almost all insurance policies, it is not going to cover discrimination. So typically this is an out-of-pocket expense for the association. Even if the association prevails at the CCRD stage, we do not have the ability to charge those attorney's fees back to an owner. So it's different than a normal complaint in terms of where we get to bill back attorney's fees. This one you can't. If you do charge back the attorney's fees, the owner can right then file a new complaint about discrimination for retaliation, and almost inevitably you are going to be found to have retaliated against that individual by putting those attorney's fees on there, and that's going to be problematic. All right, in the requested information, again, things that we're going to need, we want the governing documents, we want any resolutions, we want correspondence between you and the owner, you and anyone else that might have been discussing this, the association, anyone's discussing this. We want meeting minutes, violation logs like we talked about. We're going to need a homeowners list if there are any prior accommodation requests that have been made in the association. If the association has been brought up on discrimination claims before, we'll need photos, and then when we file the response, we're typically going to need an affidavit from at least a manager and or a board member. Again, after the CCRD reviews the information, it might request additional information and or an investigation. The CCRD will then issue the probable cause found or no probable cause found. As we already talked about, if probable cause is found, the case proceeds to conciliation, and then the case is filed by an AG office if we don't, by the Attorney General's office if we do not settle it at conciliation. If no probable cause found, the complainant may still appeal to the CCRD, or they can file the CCRC, or they can file the matter in state or federal court. All right, a couple practice pointers, then we'll get to questions. So again, make sure you adopt a reasonable accommodation modification policy for each and every one of your associations. You need to review your restrictions, your rules and regs for discriminatory language. We would advise you have the attorney's office look at that. Again, if there's anything that you get from this class today, when you hear anything about reasonable accommodation, reasonable modification, or discrimination, immediately contact your attorney. That's the best way to try and deal with these issues. Get out in front of them. There's lots of case law that if someone submits a request for reasonable accommodation and the association does not respond timely, that is a constructive denial and that you've committed discrimination without even doing anything. So that can be problematic. So time is of the essence. Obviously, make sure that, like you guys are already doing, make sure you're enforcing in a uniform and consistent manner, even if you have boards that are difficult and are wanting to use their position to maybe they have personal issues with a specific neighbor and they're tougher on them than they are on others. We need to try and limit that as much as we can. We want to make sure it's uniform and consistent. That's the best defense that we have to saying no discrimination is taking place. Engage the individual seeking an accommodation, modification, and interactive dialogue. One thing that the CCRD wants to look at is, are we talking with them? Are we asking for more information? Are they providing more information? Are we looking at different ways that we might be able to get there? As long as we're having an interactive dialogue, typically they're not going to find any type of discrimination. So that's a very helpful tool for us. Always be professional. Everything that's going to be written down, sent to an owner, sent to a tenant is going to be disclosed. So always be professional. If your association is faced with a discrimination complaint, again, be civil. Don't strike back at the person who filed the complaint. This also goes to in terms of the attorney's fees. Don't charge those back like we already talked about. Also, don't start picking on that property more than you'd pick on any other property simply because they filed a complaint. Don't ask the complainant why they filed it or the substance of it. That's the job of HUD or the CCRD. We just got to comply with the process. So get it over to the attorney's office and let them start working. Again, take the complaint seriously, be responsive, provide information quickly and truthfully. If there have been no discrimination, an investigation is going to reveal this. Understand the process under state law and federal law. So again, we've talked about it, but that's what you want to do. These are the steps that come in. The complaint comes in, you get it to the attorney. Attorney lets you know what information they need. They draft the response, and we process it through those ways. Also, keep good records. The more documentation we have regarding procedures, regarding what happened in this case with a specific owner, what happened with other specific owners in similar situations, that is all beneficial to the association. So always try and keep as good a records as you can. If you have any questions after this, please feel free to email me directly. Now I'm going to try and get through some of your guys' questions here. Start at the beginning. This question here, just age. So in terms of federal case law, in terms of pool rules and age, which I assume what this is talking about, has stated that 14 is a reasonable age to set that limit at in terms of safety. Again, we want to have the caveat of if they can show that they're a proficient swimmer, then it doesn't matter what their age is. But in terms of needing an adult there with them for safety reasons of swimming, 14 has been a good age set by federal law. The CCRD, I've seen approved rules that go down to 12. So kind of 12 to 14 is kind of your sweet spot. Could we make younger swimmers prove an ability via membership of our swim team, even if the swim team is an added cost to a member? So you can't make that be the only way that they can prove their ability to swim, but you could have it as one way to prove that you are able to swim is if you're a member of the swim team and the association knows that they are a good person, a good swimmer. But that can't be the only way that you define how someone is okay to be there without an adult. What if covenants say businesses cannot be ran out of home? So again, this one I believe is probably talking about the group home case. They're going to say that that's not a business. So it's still performing as a home, even though they're making money from it. They're going to deem that the issue is the use of the house and that you're not going to be able to say that the group home can't be there because there's a prohibition on businesses. The courts have ruled that this isn't going to be a business. This is acting as a family. The fact that they're making money is what's important. Can you ask for a picture of the ESA animals to know who is approved to have an animal, i.e. a dog? So you could certainly, excuse me, if there's a question as to, say it's a no dog, it's a no dog community. They want an ESA. They provide all the information, and there's a question as to what dog it is. You can certainly ask for identifying information of what that dog is, so we know who the specific ESA is. Typically, in this situation, you don't have an issue with that unless they're requesting multiple support animals. The case law is pretty clear on multiple support animals that they have to be providing some different benefit. Each one has to provide a different benefit. Otherwise, you're not entitled to multiple support animals. However, the CCRD has taken a different approach and has basically said there's no limit on emotional support animals, that they don't necessarily have to serve a different purpose. So it's a little unsettled there. But yes, you have the ability to, we need to know who the ESA is. So whether that's a picture or whatever, they bring the dog in so that you're aware of who it is. But we do have the ability to understand what animal is going to be the ESA. Could requiring visitors and children to be accompanied by a parent property owner when they are using a clubhouse, recreation, park area be considered discriminatory? Could requiring visitors and children to be accompanied by a parent property owner when they are using a clubhouse, rec, park area. So could it? Yes. It's going to depend on how the rule is actually written. If it's saying that anyone, so it says visitors must be accompanied on the property with an owner or presumably a tenant, that probably is not an issue. If you are saying just children or just visiting children, something along those lines, if you're carving out just children, that's where you're going to run into an issue. So ultimately, we can't carve out people by age unless if it's hey, we don't want kids under the age of 10 in the weight room without an adult. That's something similar to a pool where you have a safety issue. We could do that as long as we have kind of the caveats of if they are someone who's shown that they can do X, Y, Z, prove that they have the ability to do it. If you're worried about, the only time that we can limit the age is if there's an actual safety concern. If we're worried about them running around or their behavior, that's where you run into issues and discriminatory nature of trying to have rules. Because there you're trying to deal with behavior and you're saying children's behavior is worse and we're not going to let children do this. That's where the issue is. If it's a true health and safety issue, that's where we have the ability to try and limit. Could restricting pets from a clubhouse grounds or children playground be considered discriminatory? So service animals are not pets. So if it's a service animal, a pet would get to go there. Simply restricting pets from certain common elements, I think the association probably would have the ability to do. Pets are not a protected class. So I wouldn't see an issue with that, but you got to be careful with how you're doing it. Again, if you're going to do something like that, make sure your attorney looks at it. Do wheelchair ramps have to be removed once the owner has moved away or no longer resides at home? So we do not have the ability to require that the modification be moved once someone leaves or sells the property. So the short answer is no. More than likely, the next people who are moving in, if they don't need a wheelchair ramp, are going to remove it. But we don't get to require that they have to be removed. Insurance is requiring handrailings to be installed on the outside stairs throughout the community. These handrails need to comply with the ADA. So the only time we'd have to comply, so two different issues. From a legal standpoint, in terms of the ADA, the only time we'd have to comply with the ADA is if we're a place of public accommodation, which I would be surprised that you are, but they might be. Insurance might have a contractual obligation with you where they're saying that the railings have to be installed and that they have to be ADA compliant. So you might have a contractual obligation to install the handrails and make sure those handrails comply with the ADA, even though the ADA does not apply to your association. So it's a contractual argument versus whether there's a statutory requirement. Does a swim team meet that only happens once a year make the pool ADA compliant all the time or just during the event? So in order to be ADA compliant, the modifications that would have to be made are going to be year-round modifications. You're going to have a lift that gets people into the pool, gets into other things. So ultimately, I don't know how you could make it ADA compliant for just one day. What about wheelchair access into pool areas for handicapped residents, not ADA? So if you're not subject to the ADA and you don't have to have a, say, wheelchair access or a lift that goes in, an owner still or tenant still could request a reasonable modification that one of those be put in. So if they make that reasonable modification request, they might have to put it in at their own expense, but more than likely that would have to be allowed for them to be able to receive the benefit of using the pool. Individual owner in an affordable housing condominium community says she's handicapped and wants the HOA to reassign parking spaces so she has a handicapped spot. All parking spaces are assigned to owners. There's no visitor parking or other parking available to help her. The tricky part is that there are X number of handicapped units with assigned handicapped spaces, and some of those owners are admittedly not handicapped. It's the association required to assign. So with this one, this is from Lori. I would say this is super fact specific. You need to get that to your attorney and have them look at it. It's going to depend on a bunch of different things, whether they are just assigned, whether they are actually deeded. So there's a bunch of things that you're going to have to look at. And so I would highly advise you get that question to your whatever attorney is handling that. On a townhome committee, if someone has a renter that is requesting accommodation for parking or ramp modification, is the HOA responsible to provide? Yes, it doesn't matter if it's a renter or if it's an owner, the FHA is going to apply. There's no differentiation between renter or owner in terms of the FHA and having to provide reasonable accommodations. In the case that the association maintains the exterior of the unit and the state says they can hang items on the exterior, can the association require the owners responsible for repairing those holes when the time comes? So in terms of the religious things, probably not. Those religious items that we talked about. If it is something that oftentimes you'll have owners wanting to put in maybe a Ring doorbell camera or some other type of camera, with something like that, we would say, look, we might allow this, but we're going to require some type of maintenance and indemnity agreement that you're responsible for maintaining and indemnifying the association for any type of damage that might occur from it. So that's one way that we try and get around things like that. If a regularly scheduled monthly meeting falls on a religious holiday and no one is aware or made aware, even after an agenda is posted 5 days in advance, could it be considered discriminatory if the meeting is held? More than likely not. There may be, if an owner brings it up and says, I'm requesting an accommodation, you'd want to get that to the attorney as quickly as you can, but simply holding a meeting on a religious holiday does not in and of itself make something discriminatory. I have an owner that wants a hot tub. First request was done last year for personal use. It was denied. Second request is for his wife due to a medical condition that her body aches a lot. There are liabilities of a hot tub that could impact the HOA, leaking, flooding, etc. This is why no one has been approved for a hot tub previously. But now the wife's condition, does this change anything? There are tubs inside owners can purchase to help with conditions such as wife. So a hot tub is not the only option. So we don't get to determine what option they choose. Ultimately, if the owner provides medical documentation, the letter from the medical professional saying that a disability is in place, and that the doctor recommends that this is the accommodation, at that stage, more than likely the association is going to have to approve it. If it doesn't approve it, they run the risk of being discriminatory and having a ton of liability. Again, with all these, as we've said, make sure you get to the attorney because all these are fact specific. I'm just giving you general, obviously, off of these quick sentences, but always get these to your attorney so they can give you an actual determination of what should be going on. In the sunroom example, could you explain how the accommodation allowed for equal opportunity to use and enjoy the property for the children? The other homeowners associated did not have a sunroom. So the equal opportunity is that the children, the disability, limited their ability to use the house as anyone else would use a house. So in order for that child, those children, to effectively be able to live in that house and benefit in the same way that a normal person would benefit, they needed a sunroom that would allow the light in and provide the proper space for that child to develop. That's ultimately what it comes down to. It's not that everyone else is entitled to have it. It's that these accommodations or modifications are needed to give that individual the same benefit of the house that anyone else would have in a normal setting. Can you expand on the facially discriminatory rules that would pertain to children's play equipment? Children's play equipment completely out of the purview of the association to screen. Don't know if I exactly understand your question. Is children's play equipment completely out of the purview of the association to screen? Sorry, Deborah, I'm not sure I understand what your question is. If a townhome community, the homeowner who's in a wheelchair can exit his home, but the sidewalk poses an issue as it's not easily traversed because in a wheelchair, because of the varying heights of the concrete, there's not a smooth transition from the sidewalk to the street. Outside the homeowner's home, there's a corner that would easily facilitate a curb cut, pedestrian ramp, like other streets. Who's responsible financially? So when you're dealing with modifications, generally it's going to be the homeowner. But again, with all of these, I mean, it's very fact specific. You got to get it to the owner. I mean, typically, the general answer is that a modification is typically going to be the homeowner's responsibility. In the condo complex, HOA enacted new rules for noise for below reasons. Although many units were built with tile floors and others have converted from carpet to wood, the new HOA rule requires future conversions from carpet to add noise damping materials. Is there any discrimination in this additional cost? As long as everyone that is from X date moving forward is required to use this noise dampening materials, I don't think that you're going to run into discrimination for the additional cost. It's just simply a provision. Is it possible that a owner could make that argument? Sure, but I think you're typically in pretty good standing for something along those lines. Can you be selective in which covenant violations you cite? For example, cite a homeowner drying their bed sheets by hanging them on their deck, which is not allowed, but not cite another homeowner who has colored lights hanging on their home when only white lights are allowed. So you shouldn't. In general covenant enforcement terms, I mean, this is really not a discrimination claim as much as a just general covenant enforcement. But if you have a rule or a covenant, it should be, and someone's violating it, it needs to be enforced if the association knows about it. If the association doesn't want to enforce a certain type of rule or covenant, they need to either amend the rule or amend the covenants. But if you are picking and choosing which covenants you're going to enforce, you run the risk of selective enforcement as a defense. Would you touch briefly on whether it be considered discrimination if we have to tow a vehicle that belongs to someone who has a disability in light of the new towing laws? So simply because they are disabled would not make towing their vehicle discrimination if they are parked improperly. You have to follow the new towing laws, which we're not going to go into because there's a bunch of requirements in there. But simply towing someone who is disabled is not discrimination as long as they are violating the rules and you followed all your procedures. How do you govern residents that purchase an ESA license from the internet to go around existing pet rules? So we don't care if someone has a license that says it's an ESA dog. That's not the information we need. What we need is information from a medical professional stating that the individual has a disability. This is the accommodation that's requested, and this is the nexus between the two. The fact that they have a license is irrelevant to us. It's not something that we factor into our determination as to whether or not a reasonable accommodation needs to be granted. Can a neighbor tell another neighbor that they cannot invite friends to play on their tennis courts? I mean, a neighbor can tell another neighbor whatever they want. Ultimately, it's the association's rules that are going to apply. And so if the association does not have a prohibition on friends playing at the tennis courts, then there's no violation that's taking place. If that, I mean, it's possible that we might need to send a letter to the neighbor who is saying they can't invite friends, saying that, look, this isn't your place. The actions that you're taking are a nuisance or something along those lines. But again, it'd be pretty fact specific. The homeowner is with the friends to play has always been okay past. Yeah, again, it's going to depend on what the actual rules say. So in this case, guys, we ran 5 minutes over. I apologize. Thank you very much for sitting here and listening to me. If you have any questions, please feel free to shoot me an email. If you have any questions regarding your certification stuff, give Summer an email. Hope you guys have a great day. Take care. Bye.